by preventing intrusion by the executive and the judiciary into the sphere of protected legislative activities. So that's the basic premise of the speech or debate clause, preventing intrusion of the executive and the judiciary into the sphere of legislative activities. Going back to the very beginning of Judge Howell, giving us the larger premise on which this whole thing is set. The privilege was born primarily of a desire to prevent intimidation by the executive and accountability before a possible hostile judiciary. Representative Perry's communications with executive branch officials, as reflected in the responsive records, demonstrate that he welcomed rather than resisted, and indeed often initiated these communications. His efforts to engage with executive branch officials were proactive, persistent, and protracted. Given the clause's purpose to protect congressional members from untoward interference from the executive branch with legislative matters, Representative Perry's resilience on the clause to shield his multi-pronged push for executive branch officials to take more aggressive action is not only ironic, but also must fail as beyond the scope of the clause. So, set against the backdrop of the Supreme Court's firm statement in Gravel that a member's communications with the executive branch are political and not legislative, Representative Perry's communications with these officials are plainly not protected by the clause.